Nothing contained in this podcast is to be considered legal advice. Legal advice can only come from a properly licensed and qualified attorney engaged to address your specific situation. The matters discussed in this podcast are for informational purposes only.
Do you understand the words that are coming out of my mouth?
Quiet, numbskulls, I'm broadcasting.
Can we get serious now?
One thing that did happen during the 60s was some music of an unusual or experimental nature did get recorded and did get released. Now look at who the executives were in those companies at those times. Not hip young guys. These were cigar-chomping old guys who looked at the product that came and said, I don't know. Who knows what it is? Record it, stick it out. If it sells, all right. We were better off with those guys than we are now with the supposedly hip young executives who are making the decisions of what people should see and hear in the marketplace.
Success in the music business begins with a dream, a vision. This podcast will give you, the listener, the insight and tools to turn that vision into a reality. Meet the industry professionals who work day by day behind the scenes, helping to make those dreams come true. Welcome to the business side of music.
In the studio with us today, Dave Ratner, who is the lead lawyer at Creative Law Network. Following a career in the music business as a tour manager, publicist, band manager, and founder of his own management company, Dave Ratner is now the lead lawyer at Creative Law Network, which is a boutique entertainment law firm in Denver, Colorado. Dave counsels clients through the music industry on everything from contracts and licensing to intellectual property registration and protection to dispute resolution. Boy, there's something we could all use sometimes. He's a graduate of Cornell University and the University of Denver College of Law. He's also an adjunct professor of entertainment law and copyright law at the University of Denver College of Law, vice chair of the entertainment and sports section of the Colorado Bar Association, advisory committee chair of Colorado Attorneys for the Arts, vice president of the Swallow Hill Music Board, a founding board member of the Colorado Independent Venue Association, and he speaks frequently on entertainment law issues throughout the country. David, welcome to the show.
Thanks, Bob. It's great to be here with you.
Glad to have you. So, we always like to get entertainment lawyers on the show because they can answer the questions that the rest of us think we're geniuses in the business aren't. And if we do, inevitably, we always need an entertainment lawyer to help guide us through the maze of this crazy business we work in. Let's talk about the difference for a minute between a regular kind of a business corporate attorney and an entertainment lawyer. What really is that definition?
I think the biggest difference is just understanding the industry. Any lawyer can read a contract, but you have to know what that contract's supposed to say. If you hand a record deal to just a corporate attorney, he can tell you, oh, here's your percentage royalty. But if that percentage royalty is 5% instead of 15%, and he doesn't know it's supposed to be 15%, well, that's not very much help. So I think there's a lot of specialty in understanding the industry, and that goes beyond just the contracts. I mean, we all know how confusing, for example, publishing rights are, and all these different revenue streams that hopefully we're all collecting. But a lot of my time, certainly I'm working on contracts and we're doing negotiations, we're doing intellectual property protection. But a lot of time is also saying, well, here's how this works, right? This is what's supposed to happen in the industry. Your producer doesn't get some of your songwriting unless he or she's contributed to the songwriting. That's just how it works. Right. So knowing those kind of the ins and outs, I think, is a big part of it.
When you talk about publishing, because that's the black hole that none of us really want.
Yes, that's the morass, right?
Yeah. It's kind of Alice in Wonderland, looking through the looking glass and going, I don't get this. I don't understand it. When you go into a publishing deal, and forgive me in advance, I'm just going to kind of go all over the map here, but I know there's going to be some questions as the topics of conversation come up. But as you go into a publishing deal with publishers, and we had this conversation with another guest a few weeks ago who was dealing with the financial end of that, and it's really where she said, when you present the scenario, which is this is the music, this is the catalog, this is how much we think it's worth. She did this to numerous different managers and accountants, and they all came back with their own formula. Is this something that an entertainment lawyer can help kind of sift through that process? Or is that something that maybe should be more in the hands of an accountant or in both?
Yeah, I think it's a matter of hopefully the artist has a good team around her, right? There's a manager and there's a business manager and there's a lawyer and there's an agent. And everyone is going to have their input. I think we kind of sometimes joke that if you're good with numbers, you don't need to go to law school, right? You go to law school if you're not good with numbers. So I can't say that the lawyer is always going to be the best numbers person on the team, but it is kind of that team effort where hopefully if there is a business manager, they can really speak to what have the revenue streams been in recent years? What can we expect the revenue to be in future years? And I think the lawyer's role is definitely going to be to make sure the terms are really going to protect the artist. So it does certainly depend on the attorney. It depends on the team. And I think the value is only one of the deal terms in that publishing deal. There's a lot of other things we're dealing with. Obviously, the number of zeros is maybe the most important thing to the artist at the first look, but there's so much more in there about how long does this deal last and what future rights do they get and what sort of approvals do we have, and all those other things I think is really where the lawyer is going to really prove their value.
When you talk about those zeros that go behind a certain number, we're seeing a lot of these days, really the established artists from the 60s and 70s and even into the 80s, the Neil Youngs and the Joni Mitchells. And
I just saw Def Leppard is the newest one I just saw out there.
Oh my gosh.
So yeah, into the 80s.
I'm not looking at this from an accounting angle, but I am looking at this from the legal side of things. Does that seem, in your mind, and I'm just asking your opinion, do you think that that's a smart move that these, the Bob Dylans of the world and like you said, the Def Leppards who are selling off either a portion of or an entire catalog for monetary reasons? And then I guess maybe part two of that question is, what's driving this all of a sudden?
Yeah, there's a lot of angles on this. It's really fascinating when you look at it from just an industry perspective. And I think what's driving it from the artist side is obviously different than what's driving it from the business side or the acquirer's side. I think the businesses are seeing these copyrights, these songs as an annuity. They're saying this is just going to keep making money. And copyright lasts, the legal side is, copyright lasts for 70 years after the life of the author. Generally, there's some different calculations that sometimes can be 95 years after the date of first publication. But in either case, it lasts for a long time. So assuming that we'll use the Bob Dylan example, and his copyright is going to last till 70 years after his passing, it's a lot of years it's going to generate revenue. But from his perspective, once he's gone, what does he care how much money he's making? Right?
Right.
So so while he is certainly, and most of these artists are certainly making very good money on a year-over-year basis, they're getting those revenue streams, I can see why it's attractive to get just a lump sum. And especially at a later stage in life where you're not thinking, I'm going to have these checks for the next 30 or 40 years. If you're thinking I've only got maybe a decade left. Nothing about Bob. I don't know his health, but just in general, if you're at the end of your career, you may say, I don't have to worry about statements and accountings and all that stuff we deal with. Just give me one check. And I do think, I don't know, this is where we need to have the business manager on the show next time, is what the tax treatment is. I read something about the difference in tax treatment, about a lump sum versus those annuals and what you can do with the money once you get that lump sum. But really, for an artist, it's money in the bank, it's money in your pocket. And I think the other thing is we've certainly seen artists who pass away and the arguments and fights that go, use Prince as the example, whoever, where there are arguments and fights about that, who gets to control that catalog and where that money goes. If you are an artist who has already sold your catalog, that money is in the bank, it is your asset, and it's dealt with in your will, which hopefully you have a will, and there's a lot less to worry about, or for your heirs to worry about.
my next question is, when we talk about copyrights, and you said the life of a copyright is 70 years after the passing of the artist, what happens then? Does that become public domain, or how does that work?
Yeah, so after the copyright expires, it enters the public domain. And once copyright enters the public domain, then anyone can use it. Anyone can go and use that recording, and that applies to, copyright applies to literature and film and video and dance and all sorts of creative things. And so we do see there are properties, copyrights, that enter the public domain every year. Last year, I believe we had The Great Gatsby. Entered the public domain last year. So all of a sudden, if anyone wants to go write a sequel to The Great Gatsby, or just go start printing copies of The Great Gatsby, they can do it because it's in the public domain. So when when a copyright in a song expires, anyone can go put that song in their movie, anyone can go put that song on a compilation, or make a cover without paying mechanicals. All sorts of things happen because it's no longer protected.
Is there any synchronization fees that can be made at that point when it's public domain, or is it's just free for the taking?
Well, so it's tricky because, I often I do presentations on copyright all the time. I teach it in law school, and copyright's confusing, but it gets twice as confusing in music because there's 2 copyrights in every song. So we have the copyright in the composition. We often call it the publishing, but that's when we write a song, we own that copyright, that composition copyright. There's a completely separate copyright in the sound recording or the master, right? So what can happen if, for example, if the copyright expires on a song, you can go create a new master. I could just go make a new recording of a song, and now there's a brand new copyright on that new recording. And then if I want to go sync that new recording, well, then it's not in the public domain. It's protected by copyright. And so you can continue to generate revenues that way.
Let's talk about something else that is kind of in the same stratosphere, and that's the new Copyright Claims Board, which I guess is for small claims. Let's touch on that for a moment.
Well, we don't have it yet. So this is what's kind of interesting. There was a change, kind of a new part of the copyright law that got passed recently, and it created this Copyright Claims Board, which is something that folks have been lobbying for a long time. So the background is, if someone infringes your copyright, and you can't negotiate a settlement, you can't get them to pay you, and you do have to file a lawsuit. If you have to file a copyright infringement lawsuit, that's in federal court. It's very expensive. It's very time consuming. You're talking about tens of thousands, if not hundreds of thousands of dollars in legal fees. And nobody wants to pay their lawyer, right? They just want to be able to collect what they're due. But also, we have to recognize that a lot of, I'd say most artists out there, aren't even in the position to pay a lawyer those exorbitant fees to go after someone in court. And so what has been happening is artists' rights are getting infringed, but they're not able to go and enforce those rights in court. And this doesn't just apply to music. It applies to all those creative endeavors that I was talking are protected by copyright. So the idea of the Copyright Claims Board is basically, this is a small claims court for copyright. And hopefully most people out there have not had to go to court. But what small claims court is, you don't have to you actually can't bring a lawyer. Everyone represents themselves. The filing fees are reduced. It's a much simpler, quicker version, I guess, if you want to use the kind of Judge Judy People's Court example. It's quick and hopefully inexpensive. So the Copyright Claims Court is basically meant to be a small claims court for copyright, so that artists or rights holders whose rights are infringed have a way to go and pursue infringement actions in court without all those fees and hoops to jump through.
Is there a financial limitation on that for recovery?
Yeah, it is. The amount in contention is limited. Unfortunately, there's a number of limitations, and the court is not set up yet. We're almost there. It's being set up through the Copyright Office. So we don't really have all the rules of the road yet, but there are, and therefore, forgive me, I haven't memorized them yet because we haven't had to do it. But there are limitations not only in collection, but also I believe that both parties have to agree to go to that level of court. And so that can be tough because you may have the other side say, oh no, we're going to make you spend. But always remember, both parties have to spend a lot of money to go to court. So the idea is both parties will hopefully agree that we'll go to this small claims court where it'll be cheaper.
It almost sounds like there's a certain amount of, I don't know if I want to say arbitration, but maybe it's a certain amount of counseling with both parties to at least get them to that point before they walk in that court door.
And I expect we will very quickly, once we're rolling, we will very quickly have some kind of guidelines, FAQs, some stuff that'll help people navigate this, because we really want, the goal of it is so that people can do it themselves. And I think we will have a lot more information available, just kind of basic information to help people make those decisions. But also I'd say what I expect to happen is I'll be working with clients who will go and represent themselves before this in this small claims court. Even though I'm not there, I'll be able to help them get to that point, because there still is a certain amount of counsel in just, first of all, understanding the law and the claims you're making, understanding where the line is, because it can be a very blurry line for infringement. So there's still, a lawyer still has a role here. It just won't be years and years of litigation. And I think it'll just be hopefully a lot quicker and streamlined.
In the studio with us today, Dave Ratner, who is with Creative Law Network.
Hi, this is John M., singer-songwriter and author of Performance Matters, a guide to live music performance. And you are listening to The Business Side of Music with Bob Bender.
You're listening to The Business Side of Music.
Hi, everyone. I'm Larry Butler, and I want to send you a free digital copy of my new book, The Singer-Songwriter Rulebook, 101 Ways to Help You Improve Your Chances of Success. That's right. Everything you need to know to launch your career as a singer-songwriter, all based on my 40 years in the live performance arena. And believe me, I've seen it all. In my book, you'll find the 10 things you have to deal with before even thinking about becoming a singer-songwriter performer. You'll also learn about the 5 things every singer-songwriter can do this weekend to make their live show better. 5 things I can guarantee that you are not doing already. Plus, there's tips on songwriting and staging, photo and video shoots, publishing, merch, dozens of other topics, all written for people who don't particularly like to read. And again, it's free. Just go to the Business Side of Music website homepage and look for my book cover. Click on it, and a free digital copy of my book will be yours. I'm Larry Butler, and I approve of this message.
Whether you consider yourself a musician or not, music is all around us, and it affects our everyday lives. Whether it's background music influencing our shopping habits in a store, organ music adding the vibe to a baseball game, or a playlist convincing us to keep going on that last mile of a run. I'm Mindy Peterson, host of the podcast Enhance Life with Music, where we take a holistic look at music's benefits through the lens of science and medicine, entertainment, and business. You can find me and Enhance Life with Music at mpetersonmusic.com/podcast or wherever you get your audio.
You're listening to The Business Side of Music.
Let's talk about something else that has been a topic of conversation with a lot of my friends, especially those on the road touring, or maybe I should say who've not been on the road touring.
Right.
Because of COVID. We've had booking agents on the shows. We've had managers on the show. And when we have that conversation of, well, how's it going? You're getting out on the road or you touring? And they're like, yeah, not so much. And in fact, had a conversation with a buddy of mine who's in a well-known rock band. And he said, what's going to happen to all these deposits? He said there were literally hundreds of dates out there and deposits on many of those. I said, well, first of all, you're not going to get the deposits, but it was all driven by COVID. And so is there a remedy for that? I mean, obviously, we don't know how much longer this is going to be around, this pandemic. Is there a COVID clause in contracts, in any contract, or should there be a COVID clause in the contract?
Oh, there's a COVID clause now. I mean, there wasn't a COVID clause 2 years ago,
Yeah.
but you can guarantee there's one now. And it's so hard, Matt, right? We know that shows are just being rescheduled, or we're having shows go off, but there's not as much of a crowd in the house. Ticket counts are certainly down. And so it's hard for everybody. I will say the encouraging thing that I found for a lot of the folks that I was working with just a little less than 2 years ago when everything shut down was that there was kind of a we're all in this together sort of attitude, where I didn't see a lot of people fighting over deposits because it said we will reschedule,
Right.
There were return deposits. It did happen. But the venues have struggled so much as well. I mean, we have lost so many venues. I can speak for here in Colorado. Far too many venues just shut down permanently, which really upsets the entire balance of the touring industry. With less rooms to play, that changes the dynamic of the negotiations and everything else. But we now do have COVID clauses in contracts, but it's not all that different. I mean, there's a legal term called force majeure. And force majeure is basically when something out of the party's control prevents the contract from happening. So force majeure, we often say it's an act of God. So that can be, it could be a fire or an earthquake or a tornado. So it can be a weather event. It could be if the utilities go out. It could be if there's a government regulation preventing us from having the show. And we certainly saw that happen early on. And so some force majeure clauses were called into effect. But now especially in the U.S. here, we're not seeing government regulations are not preventing shows from happening. We're way past that. So COVID clauses are more, I think, covering if someone gets sick, what do we do? But I think the other thing we thought would happen early on that didn't come to fruition was we early on were talking about the risk, the liability of someone getting COVID. So there was this, I think a lot of venues and artists were concerned, what if someone gets COVID at the show, can we be liable? Can we be held liable? And at this point, for the most part, you get COVID, you have no idea where you got it. It's just everywhere at this point. So we're not seeing lawsuits from folks at shows saying I got COVID at your show and I'm and you owe me damages. So there I can say if there are silver linings or bright spots, it has not been as bad as we thought it would be in certain ways.
And I would have to ask the question: Is there a financial benchmark that, okay, I got COVID because I went to your show, I'm seeking compensation? I mean, is there seriously a number that you could expect, or are you just kind of, how do I want to say that? Are you just throwing rocks into the water and hoping you hit something?
Right, shooting in the dark.
Yeah.
I mean, so certainly any lawsuit has to allege damages, right? So if someone said, I got COVID and I couldn't go to work and I got fired, which you're not allowed to fire someone for getting COVID, but they'd have to claim they had some damage. And certainly, I think the most obvious one is health effects, right? If you actually are, there's injury that can result. But we really have not seen that happening as far as shows, as far as live performances go, because there's certain assumption of the risk, right? If you're going to a large gathering in a crowded room with a bunch of strangers during COVID, you're assuming the risk, you're accepting the risk of COVID. And certainly you could wear a mask, whether we have mask mandates or not, in wherever you happen to be. So we're really not seeing those sort of damages being alleged. At least I'm not aware of them. And it's not something that's been happening to any of my clients.
But at the same time, we still now have this COVID clause to really help, maybe I should say, maybe not prevent, but help prevent any issues that might come out in a live performance, in a venue, or in other appearances. That really is something that is new that we've just seen in these contracts now.
Yeah, and I should clarify, it's in a contract between the artist and the promoter, or the artist and the venue. So the fans aren't party to this contract, so it's not about them.
Right. Yeah. Yeah, we want that clarification.
Right.
Yeah.
That COVID clause does not protect the guy in the front row.
Yeah.
But it is about what, if a member of the touring group does contract COVID, test positive, then you have to cancel the show. And how do we deal with that? Like you said at the beginning, how do we deal with the deposits, things like that?
Another topic of conversation, and this is something that we discuss a lot on this show, and that is the varying label and distribution deals that are out there these days, that are being offered to small independent artists. Is the record deal, from your perspective, and once again, I'm just looking at your opinion, not legal advice per se, but from the legal perspective, if that makes sense, is the record deal the smart way to go these days with the independent artists? Because there seems to be a lot of different things out there floating in the atmosphere.
There are, for sure. And nothing I say today is legal advice. So thank you for pointing that out. I can only give legal advice to clients. But it is there are so many options out there. Going from where a few decades ago, the only model was really the major label deal. We're now all over the map. When a client, I work with labels, and a client will say, well, I'm starting a label and we want to draft a record contract. And I said, well, that could be a million different things. It can go a million different ways. And one of the reasons we've had all those changes is because you don't need a label to release an album. Right? TuneCore, DistroKid, CD Baby, do it yourself. So what does a label bring to the table? Well, a label should be doing promotions. It's advertising. It's marketing. Right? Their job, just very, very basically, I'd say, is to get the music out there and get people to listen to it. And so a lot of times when I'm having the conversation with an artist client about, are we interested in a label deal? I've started very basically. It's like, what do you want a label to do for you? What is it that a label can do that you can't do on your own? Because there's a very common misconception that a label, for example, you get an advance in a label deal, that's not free money. That's an advance on future royalties. That's just saying this is a deposit, but we're going to take it right back out. So if you get a $10,000, $100,000 advance, you're not going to see any royalties until the label recoups that entire advance. So if an artist says, oh, I just want money, well, that may or may not be the best way to make money, but that's not usually what the artist says. The artist is usually saying, I want my music to be heard, and that is entirely legitimate. I think we certainly want to talk, or you want to be looking into what is the kind of exchange that's going to happen. So it's very common, for example, in a label deal, for a label to own the masters. Well, the reason that used to be is because a label would pay for the creation of the masters. Label would pay for all the studio time, would pay the producer fee, would pay the side artists. Well, I see label deals now where the label wants to own the masters but doesn't want to pay for anything in the creation of the masters. So is that a fair deal? Well, it depends. Does the artist care? Is that important to the artist? So I'm working on a deal right now for a new label where they're just licensing. And they say, we'll license these tracks for 10, 15, 20 years, and then you get them back. That's a very different model. And I always want to make sure people understand, or the artist anyway, understands the exchange, with the give and the get. What do you know what you're getting from this label, what are you giving up? And that's a very kind of basic first look or first way of evaluating a deal.
Owning your masters as an artist, I would assume, would be almost a non-starter in discussions. You as the artist would want to own your masters.
Sure you do. It's just are you willing to give up? I mean, we have a starting point.
Right.
But if the starting point is the label has to own the masters, well then, is this the label for you? That's the other thing. I mean, I think that You want your music to fit with that label, however you want to characterize that label, whether it's their genre or their ethos, whatever it is. You want to fit with that label. You want to have a good relationship and trust in those folks you're working with. Know their track record. If you can talk to other artists on the label, find out how they're doing. Are they getting their royalty statements? I can't tell you how many artists contact me and said, I have not seen a royalty statement in years. And it's a pain, and you want to make sure you've got a trusted partner.
Yeah, and that's the big thing is, and knowing what the royalty statement is and what it should be saying.
Sure. Yeah. I mean, and it's tough because there is a lot of trust involved in the sense that you're trusting them to do proper accounting. Now, any label deal that has royalties being paid should have an audit provision. The artist is allowed to audit the label's books, but an audit's expensive. You're not just doing an audit on a whim. It's an endeavor. So hopefully you're not going to have to audit folks, and hopefully you're working with a label who has their poop in a group. I mean, when people go and feel, look, anyone can start a label these days, and that's great, and it's horrible because I have an artist out in LA who's working with a producer who started his own label, and I'm looking at this label deal, and I said, okay, well, he has to account to you. Does he have an accounting? Does he have an accountant on staff, a bookkeeper who's tracking all that information? It's a lot of information to track every stream or every penny that comes in and know which song it attaches to and what has to be recouped before what royalty is paid. And there's a lot of detail. You got to kind of know what you're getting into. And it's tough because, as we said before, this is a really confusing industry. We spend a lot of time just navigating how all this stuff works. So an independent artist hopefully has a manager who knows how it works, hopefully has a team behind her or him, because ideally the artist can focus on making music. But I think the threshold question for me is always, why do you want a label deal? What are you expecting to get out of it?
A 360 deal. We hear that number thrown around. We hear that description thrown around a lot, the 360 deal. Is it a good deal or not?
Oh, that's I wish it was that simple. Okay. I wish it was that simple. So is a 360 deal a good deal or not? This really depends on the label. Because, let's clarify, a 360 deal, what it is. A 360 deal is where the label is involved in all of the artist's revenue streams, the entire universe of the artist's revenue streams. A traditional label deal, the label is getting a piece of the revenue that comes from the masters. That's all the label deals with. The label doesn't traditionally deal with the publishing. It's just master revenue. But what 360 deals came into being because of online music, because we weren't selling CDs. Labels had made so much money on CDs for so many years that they suddenly were not making any money or nearly enough money from streaming and downloads. So they said, well, where's the other money? And there's money in merchandise. There's money in ticket sales. There's money in publishing. So a 360 deal is the label is getting a piece of your merchandise, getting a piece of your ticket sales, getting a piece of your publishing revenue. And the reason I say it depends on the label is because a label needs to actually, in my opinion, representing an artist, a label needs to earn that money. So a label needs to be able to help with merchandise and provide tour support for ticket sales and really earn that percentage of those revenue streams that it is collecting. Because if you're doing a 360 deal with a label that doesn't do merchandise and that doesn't do tour support, well, then the label's getting something for nothing. And that's certainly not a good deal for the artist.
And that in itself is a double-edged sword because, as you mentioned earlier, an artist, hey, I just want money to go on the road and tour, record an album. The artist seems to forget that there's a word attached to that, and you used it earlier, and that's recoupable. And it's not dollar in, dollar out.
Yeah.
Typically, it's for every dollar they spend on you, they're going to want to recoup $3 or $4 before you're going to see any kind of royalties. So
well,
does
if
the
they
360?
they should only recoup $1 for every dollar they spend.
Sure, they should. I agree, but it's that's why labels will spend a lot of money on an artist to break them. Taking a song to radio, the radio tour campaign, or providing tour support. That turns out to be a lot of money. And I think sometimes that the artist doesn't realize how much money gets spent that quickly.
I completely agree with you. I mean, I'm for all our friends out there who are on the label side, we're with you. Like, I'm not taking. There's two sides to every story, and the labels have a tough job.
Yeah, absolutely.
They're trying to make money where it's hard to make money off of music. And it's funny, or I find it interesting how the bad guy, is the label the bad guy? Is Spotify the bad guy? Is the promoter the bad, right? It's like everybody is trying to make money here. And the pie is only so big, and that's a challenge. But you're absolutely right that the traditional label deal involves recoupment, as do publishing deals, by the way. Right? Publishing deals involve recoupment as well. And so that entity, that company, is going to spend money to promote the music and then recoup that money before splitting the profits. And that royalty is a percentage of profits.
And once again, that recoupable amount can grow exponentially rather quickly on everything they do. And you said it. They've got such an extremely difficult job, and we have to remember it's not just one label. There's dozens, if not hundreds of labels out there, all trying to get on radio and trying to get wherever that digital retail marketplace is anymore, the physical marketplace, and there's only so much room.
Exactly. And there are so many. I mean, look at the problem we're having producing vinyl right now. Right, the backup in making vinyl. That's not the label's fault. It's not anybody's fault. But we certainly hear about how there's a great profit to be made, great margin on vinyl. You just can't buy it right now.
Yeah, can't get it manufactured. Right.
Exactly.
Yeah.
Right. So there's so. But yeah, you can spend endless amounts of money promoting the music, and that's honestly, Bob, one of the toughest things about this industry. You mentioned before I was a lawyer, I was a manager, I was a tour manager, and this was true then, it's true now. It's just, it's hard to get the music listened to. It's hard to get out there and get ears listening to your music. Unfortunately, when I was a manager, I was representing some amazingly talented musicians who just couldn't catch a break, and it wasn't because they weren't making great music. Right? You can make the best music out there, but this is where the label comes in. Is getting people to listen to that music.
In the studio with us, Dave Ratner, who is with Creative Law Network out of Denver, Colorado.
This is Sarah Beth Peary with the Band, coming live from Nashville, Tennessee, and you're listening to The Business Side of Music with this crazy guy, Bob Bender, hosting the show. And that's only because he won't let anyone else have the microphone, well, except maybe me.
You're listening to The Business Side of Music.
As a musician, you have a dream, that vision of what success looks like for you. Though it's not only about the money, money is a part of it. Whether you've been extremely successful or just striving to maintain a regular cash flow, you need a plan. Money Concepts can help you develop a customized plan to achieve the financial stability and success you want. For over 40 years, Money Concepts has been providing holistic financial planning services to individuals, families, and business owners. As an independent firm, Money Concepts and their associates are committed to always represent the best interest of the client. It's really about independence coupled with committed benevolent interest, which means that they can represent your client, not a product supplier. It's not about selling products. It's about helping you achieve success. To learn how this can benefit you, contact John Adams at 737-867-9309. That's 737-867-9309 for more information.
You're listening to The Business Side of Music.
One last question before we let you go for the day, and we kind of seem to be dancing a little bit lightly around this topic, but the virtual music experiences, and, do we incorporate such platforms as Spotify into that, or TikTok or YouTube? But let's go down that path for a minute of the virtual music experience.
When you say virtual, you think just digital, or are you thinking about like virtual reality? All of it?
Well, I think that's a whole nother topic of conversation. In fact, we just chatted about that on the show a few weeks ago, that, you know, you're now looking at Peloton, you know, providing music for Peloton platforms. Who would have ever thought? But let's talk about, like, say, and I don't mean to clump them together, but let's simplify it. So you have Spotify and you have TikTok and you have all of the, you know, Snapchat, anything that's using music.
All this social, sure.
Yeah, and that's a relatively new world too. Are we navigating those waters as best as we can for the benefit of the artist? Or is that still such uncharted territory?
We're getting some charts. I mean, we're getting there. I think that certainly the digital distribution of music, so the Spotify, the DSPs, right? The Spotify, Pandora, Tidal, all of these, we've got a much kind of clearer roadmap there than we do on the TikToks and on the Snapchats. Because music has been available over the internet for a couple of decades now. It makes me feel kind of old to say it, but that's you know, it has been a while. That Napster was a long time ago now. And so I think that it is still controversial to a lot of folks in the industry because we remember the days of CDs and cassettes, but we're not going back there. And so this is the world that we live in. And I do see, certainly, I think the biggest arguments that we see publicly are just about royalty rates, about where the money trickles down to. On the social side of things, though, on the TikToks and other social media platforms, man, it is wild because we're linking music with video. And I'm not just talking about music videos, but as you know, on TikTok, there's music in the background of most of these videos. And how are the artists getting paid? Or are the artists getting paid enough? There's also, I think if we go back to the origination of YouTube, we had a lot of fights. There was a very, very long and expensive, almost decade-long lawsuit against YouTube when that first started. And it shakes out. It does get figured out. YouTube has, I don't think it's great, but they do have a system for monitoring the music on the platform. And I'll tie the law into this. I don't want to get too wonky on us, but the copyright law has a provision that allows for music to get taken down off the internet when it's being infringed. So simple example is if you're an artist, you see your music in a YouTube video, but you didn't give anyone permission to put that music in that YouTube video. You can say, YouTube, take that down. It's called a notice and take down procedure. And it's very well established in the copyright law. There's currently or has been for a while, a conversation among lawyers about, is this system working? Is this notice and take down procedure working? Because it becomes a game of whack-a-mole where you take down one, you find five more, and you're just constantly trying to quash them, and it's really impossible. And there's no copyright police. There's nobody to enforce your copyrights except yourself or whoever you hire. And so and when we have these platforms on such a gigantic scale, it's really hard to govern. So I think it's a great opportunity for people to get their music out there. We see certainly you can be, TikTok stars are now, it's quite a thing. And music in these videos gets heard and gets listened to and gets purchased. I mean, people will hear music in a social media video and then go find it on their Spotify or whatever platform they choose. And that turns into money for the artist, ideally. But there's still a lot of problems along the way that we're still trying to solve.
And the artist, you said it, the artists themselves or their immediate representation, they have to be on top of this all the time to make sure that they're being protected and they're being compensated.
Yeah, it is incumbent. Unfortunately, it falls on the artist. Well, or whoever is on the team. I mean, if we have signed a label deal and the label owns the masters, the label is out there enforcing. So we see that a lot. So I'd say it's on the artist side of things to do that enforcement.
Yeah.
Whether or not it's the artists themselves.
Dave, thank you so much. This has been a wealth of information today.
Well, thank you, Bob. It's so much fun to talk about this stuff, and it's a pleasure to get to chat with you, and I hope we get to do it again.
The Business Side of Music is the creation of Tom Sabella and Tracy Snow and is produced by Bob Bender. The Business Side of Music is recorded at Music Dog Studios in Nashville, Tennessee. Production sound design by Keith Stark. Voiceover and promo by Lisa Busan.